hearing in the appeal, Routier and another. Shall the Commissioners for Her Majesty's Revenue and Customs?
Yes, Mr. Steinfeld.
Yes.
We are aware of the representation, of course, so there's no need to repeat it. We've been discussing matters, and it seems to us that we ought to hear all the argument on the issue of Jersey and whether Jersey is or is not a third country, because on the answer to that, much else will depend. And a great deal of discussion on one view of the answer to that and of what EU law requires, much of the discussion as to the domestic law interpretation of Section 23(6) falls away. So we would like to propose that we adjourn for 5 minutes or so while you discuss amongst yourselves how you present the argument on the Jersey third country issue. I don't know how much of time you were intending to devote to it. Obviously, we've got 35 minutes for the Attorney General, something like that. And I don't know how much time the government was proposing to devote to its contrary argument.
You've probably seen from our written case that I was intending, at least in opening, to deal extremely briefly with it, and simply to rely on the analysis of the issue and the judgment of the Court of Appeal in the second hearing, the judgment of Lady Justice Arden, as she then was, which you probably looked at and and leave the rest of the running, as it were, to Mr. MacDonald, who's been given leave to intervene, representing the Attorney General of Jersey, and Ms. Bacon dealing with for the revenue, and reserving any points I might have, further points, for reply to HMRC.
Well, would it be helpful if we did just adjourn for about 5 minutes to confirm? I hope you're going to be ready to do things in that order.
My lady, might I propose that, given that effectively it's the revenue's appeal on the third country issue, so they're appealing from the judgment to the Court of Appeal on that point, that they go first.
Yes,
on that issue.
that makes sense. That makes sense. Speak. Yeah.
I am content to go first, and I'm ready to start my submissions if that would be helpful.
Well, if you don't need us to adjourn, we won't adjourn.
I don't need you to adjourn, and if there is a breakout of agreement as to who is going to go first, I'm very happy to start.
I'm more than happy. There will have to be, obviously, an adjustment to the timetable in terms of the sequencing.
That's why I was proposing that we would just adjourn for 5 minutes so that you could rejig the timetable. And probably that's quite a good idea. So shall we do that? And we'll return. Sorry? Yes, I should also make the point that we hope to be able to form a view on that issue after we've heard the argument about it, and to let you know so that you can then think what effect, if any, because it depends what we think, it has on the rest of the argument. That also makes sense. I mean, that was fairly implicit in what I was saying anyway, I think. Yes. Good. 5 minutes. Yes, Ms. Bacon.
My lady and my lords, we have conferred, and we think that we will be finished this morning on the Jersey third country issue.
Well, that's very convenient.
And
well done. Keep at it.
Yes. So the proposal is that I will start.
Yes.
We will then have the intervener and the appellant, and I will have a short reply. And we think that should take most of the morning, if not all of it.
Yeah.
As you all have seen from our written case, the Revenue's primary position is that the answer to this question is not act clair either way, and it should be referred to the CJU if two conditions are present. The first is that the issue is necessary for this court's judgment, and the second is that by the time of the judgment, this court is still in a position to make a reference. Now, we had hoped that the position on the latter of those 2 points might have become clear by today. Unfortunately, recent political events mean that there's still no uncertainty whatsoever as to what position we will be in after the 12th of April.
We are simply behaving that we are currently members of the EU, we are bound by EU law, and we are behaving in that light.
Absolutely. And with that in mind, we have prepared a draft question for the European Court in the event that this court is minded to make a reference more or less immediately, as this court is still able to do. It is in very neutral terms. I've shown it to my learned friends just this morning, obviously the other side has not had a chance to take instructions, but as I've said, it is framed in very neutral terms and simply asks essentially the third country question. Now, in the event that by the time that a decision is taken by this court, we have left the EU on terms that do not permit a reference to be made. And again, if the issue is necessary for this court's judgment, then our submission would be that the decision should be in favour of the revenue. But as my lady, you have just said, at the moment, we are not in the position that a reference cannot be made. A reference can be made today and will be able to be made at least until the 11th of April. I propose, rather than dividing up my submissions between the primary and the alternative cases, to address both at the same time by making 7 consecutive submissions which build on each other. And if I can summarise them, the first is that there are different arrangements in place for different territories associated with different EU member states. And the rules for each of those territories are not necessarily the same.
I would have thought that was an uncontroversial
It should be. In fact, I'm hoping that many of these will be uncontroversial, at least until we get into the meat of it. The second point, again, which I would hope would be uncontroversial, is context is everything. And the fact that a particular territory is treated as a third country for one context does not mean it should be regarded as a third country for a quite different context. The third point is that the particular context in this case is the application of EU law to transactions between a member state and its own associated overseas territory. And in that regard, the Prunus case, which has been heavily relied on by my learned friend for the intervener, concerns the different situation of a transaction between a member state and a territory associated with a member state. So in our submission, it doesn't provide an answer. That's the third point. If you are searching for a precedent case, the closest precedents are the cases that concern this situation of free movement between a member state and a territory for which that member state is responsible under EU law. And the 2 precedents in that constellation are the Jersey potatoes and Gibraltar cases. The fourth proposition is that the intervener says that the decisions in those 2 latter cases, Jersey potatoes and Gibraltar, turned on whether the relevant provisions of EU law themselves took effect in those territories. But in fact, as I will show you, a key consideration in both of those cases was the close relationship between the UK and those territories for which it was responsible. So the rationale underlying Jersey potatoes and Gibraltar is my fourth point. My fifth point concerns the ex-BV case, which is the only case to consider the particular situation we have here of how Article 56 applies to a member state's associated territory where Article 56 does not itself bind that territory. And in XBV, the court avoided answering the question. But as we've set out in our written case, the Dutch court's view was essentially the one that I'm advancing today, which is that it would be a wholly internal situation. My sixth submission is that in light of the first 5 propositions, and in particular the fact that the court left open and explicitly left open in the XBV case the question of how it would determine the question that arises now, indicates that a reference should be made if this court is in a position to do so and if an issue is necessary for the judgment in this case.
You say that we must make a reference.
We say that if it's necessary for the judgment, then yes, you must make a reference because it is not Act Clare. And as things stand now, yes. As in that we are still a member of the EU. Of course, you could decide that it's not, as did the court below, that the issue is not necessary for determination in the case. And indeed, the court in XBV didn't answer it because it thought it wasn't necessary. But our position is that if it's necessary for this court's determination, then a reference, as things currently stand, must be made, yes. Now, the 7th submission is if for whatever reason a reference cannot be made, and this court therefore has to decide the question for itself, then our submission is that this should be a decision in the revenue's favour on the basis that the close connection between Jersey and the UK points in favour of this being treated as an internal situation. And with the leave of the court, I will develop that submission today because, of course, although I'm putting it under the heading of what to do if a reference cannot be made, it still feeds into the decision as to whether a reference should be made, because it builds on the points of, concerning the close connection between Jersey and the UK to show that my learned friend for the intervener's proposition that this is all Act Clare against me is in our submission not correct.
Can I just ask one, we're being asked to decide this in the context of the construction of a slightly esoteric statutory provision of the tax code, but I'd have thought it has much wider ramifications than that, the question of whether Jersey is to be regarded as a third country.
Yes.
To the extent of I'm surprised in a way to find this being raised and there being a difference between the British government and the Jersey government on an issue which I thought was a high policy.
Yes, well, we would agree with that, and that is why in the court below, Mr. Yates did ask at that point for a reference to be made, and that there is a concern on the part of my clients that it may well have much broader ramifications. And that is indeed a factor that underlay the decision to ask for reference below. Of course, in this court, the question is not a matter of discretion. If this court decides that it's necessary to determine it, and if you...
Yes, I was thinking rather more generally. I mean, I'd have thought this would have been discussed as a matter of high policy between the British and Jersey governments before one started worrying about what Europe thought.
Yes, I think the problem there is that Jersey takes a different view as to the ultimate resolution of the question, and it's not for me to develop the intervener's case, but the intervener's position has always been that it is Act Clare in his favour, in that Jersey should be treated as a third country.
And so the argument you're presenting isn't simply an argument on behalf of revenue in a tax appeal, it's the position of the British government as a matter of high policy in its relations with the Channel Islands.
Well, my instructions come from the revenue. My clients are not the government generally. My instructions are from the revenue in this case. But of course, your Lordship is right to say that we would, of course, have liaised with other departments within government in presenting this position.
Take that for granted.
Yeah, I'm being reminded, of course, that we are proposing a reference in a particular legal framework and particularly legal context which concerns the application of Article 56, and that's indeed part of the argument that I was going to develop. So it may well be that the answer that is given, if it's referred, that the answer that may be given by the Court of Justice may not have ramifications beyond this particular context.
Of course it
but
will.
that can't be. But because the question will be directed at the particular context of Article 56. But I agree that as a matter of general policy, it could have wider constitutional implications.
Well, I mean, to give one example, you'll be well aware of I imagine, of the litigation that's been occupying the courts for the last 15 years or so over corporation tax. And that aspect of our relationship with other parts of the EU. It's just one illustration. I mean, it's not confined to tax either, but even within the realm of taxation, the implications of this are very wide indeed.
Yes, my lord, I would accept that. As I said, that is why the revenue has, since the Court of Appeal asked for a reference to be made, because the revenue is aware, certainly in the revenue sphere of activities, of the potential broad implications of this. And
are other departments aware, for example, that this litigation is going on?
Yes, that is the case now.
I could see that it would have all sorts of ramifications for Home Office policy.
It might. And I say it might because we have, as you, my lady, you will, and my lords, you will have seen, we have asked for the question to be framed in quite specific terms, and it is the court's general practice to answer the question in quite specific terms, sometimes slightly different to those put to it. But it is also the case that the advocates general sometimes may comment more widely on the implications of the reference. And it is the case that in our submission, for the reasons I was going to develop, as far as we understand the court's case law, this issue is wide open. The court was offered the opportunity to answer that question. It was specifically asked a question that is almost on all fours with the question that I'm proposing in XBV, and it avoided answering it and left it explicitly open. So a shortcut, if you like, could be to say that question was asked in XBV, it wasn't answered, it remains unanswered, and if it's necessary for the judgment of this court, then it should be referred for that reason alone. But of course I do want to show you why I think there is merit in our submission.
Yes, indeed. Carry on.
So that I set out my 7 headings, yes. And if I then could turn to the first one, that may be, as my lady, you indicated, a fairly short submission, which is that there are different arrangements for different territories. And that reflects the particular nature of the relationships of different territories to the EU. And there are several cases in which advocates general have emphasised this point. And if I could just take you to a couple of those by way of scene setting. The first is Advocate General Tizzano in the Commission and UK case, and that's in the 5th of the authorities bundles, tab 63 at page 2019. Now, this was a case concerning whether the UK had breached European law by failing to implement a series of directives in Gibraltar. And as the court will be aware, Gibraltar, like Jersey, is in the position where some of the EU rules apply and others do not. And in particular, Gibraltar is outside the customs union, which was relevant for this case. And during the course of the argument, the Advocate General rejected at paragraph... actually, it was paragraph 68 on page 2021, rejected a Spanish argument that the unity of the concept of the internal market implied the indivisibility of the treaty freedoms. And then he went on to say at paragraph 70, it seems to me that while it is certainly true that the concept of the internal market is a single concept, which encompasses all the freedoms. That does not mean it's something other than those freedoms. Still less does it mean that they merge their specific characteristics so as to become indistinguishable from one another. And then he built on that to then comment at paragraph 72 on the fact that certain territories were excluded from one or other freedom, referring then over the page, at the top of page 2022, specifically to the Channel Islands. And then at paragraph 73, to draw your attention to this paragraph, because in the reported version there are some words missing, so I should give you the missing words. Paragraph 73 reads, "Thus it does not strike me as strange or odd that the treaty," and then the missing words are these, "should provide in respect of territories with a specific status, such as that of Gibraltar, for an equally specific regime under which the freedoms of movement are tied in with the general regime in different ways." And we would essentially say that the same is true of Jersey, that there are different provisions relating to different freedoms.
It sounds entirely right, but could you just read those
Yes.
inserted words?
The inserted words. So in the second line, "Odd that the treaty should provide, comma, in respect of territories with a specific status." And the other case I wanted to show you on this, if you like,
before you move on,
yes,
speaking, that it's right, isn't it, that the Advocate General concluded that Gibraltar had to be treated as a third country for the purposes of the subject matter of this case?
Yes, and I was going to come on to the context in which that arose, because in my submission that was a particular context in which the question that was being asked was about the territorial scope of EU law. And it seems to me, in our submission, right to say that that does not necessarily have a bearing on a case for a different context concerning movement between one member state and its associated territory. And I am going to deal with that case and indeed other cases falling into that category. And the second of my headings, which I'm going to come to shortly. But before I get to my second heading, I wanted to show you one other case, which was the Advocate General's opinion in the Prunus case, which is in the third authorities bundle at tab 30.
Page, please.
And the page 1241. There are two references, one at 1241 and the other is at 1243. Two paragraphs of the Advocate General's opinion. Paragraph 31, where he describes the OCTs, which were an issue in that case, as hybrid bodies halfway between a third country and a territory forming an integral part of the Union. And then at the end of that paragraph, he emphasises the sui generis character of the relationship of association between OCTs and the Union. And then he makes the same point, essentially, at the end of paragraph 39, 2 pages on, where, having looked at some of the cases concerning OCTs and their categorisation as third countries or otherwise, he concludes all of the following confirms that there is no categorical answer to the question whether an OCT should be characterised as a member state or a third country, and instead the answer varies on a case-by-case basis according to the relevant legal framework and taking into careful consideration the objectives pursued by the special arrangements for association. And we would say exactly the same about Jersey as the Advocate General said about the OCTs here. In our submission, it's clear that Jersey has a sui generis relationship with the EU, which means that there is no single answer to the question whether it should be classified as a third country, but it varies on a case-by-case basis, taking into account the legal framework in question. And that is why my second submission is headed "Context is everything," it is exactly the point that the Advocate General is making at the end of that paragraph.
Sorry, which paragraph was it?
That was 39.
I thought it might be. Yes. Yep.
It's page 1243.
Yes, got it.
So my second heading was "Context is everything." It is under that heading that I was going to address the Commission UK case, because in my submission it's important to distinguish between several quite different contexts that have arisen in the case law, where the question has been posed as to whether a territory is to be regarded as a third country or as part of a member state. And in my understanding, there are at least 3 different categories of cases. There may well be more, but it's sufficient to refer to at least 3 for the purposes of my submissions today. The first category of case is where the question is whether certain rules of EU law apply in a particular territory. The Commission versus UK was one of those. And Van der Kooi, which is a case that is referred to by the intervener, was another, where the issue was the application of the VAT rules to the Netherlands Antilles, and that in turn depended on whether the Netherlands Antilles was to be regarded as within the territorial scope of the 6th VAT directive. And so both of those cases in our submission concerned the territorial scope of EU law. So it was for those purposes that the question was being asked, is the territory in or is it out? The question was whether certain rules were binding in that territory. And that was the question in Gibraltar and the underlying question in Van der Kooi. A different kind of case, and one which I would say put in my second category, is one involving standards, where the question is how to treat territories that fall outside the scope of the relevant EU rules, but have close regulatory alignment with the EU or some other equivalent standards. Again, the legal context is quite different to that of my first category, and indeed quite different to that of the present case. And an example of this second category would be legislation concerning data protection and financial regulation of the type cited by the intervener in their written case. And in that second category situation, where there are particular rules for countries or territories that do not apply the EU rules per se, but do have similar or equivalent regulatory standards, it makes perfect sense that a territory such as Jersey should be in that category of third countries. It's a categorization that is made for a very particular and very different purpose to that arises in this case. I would then put in a quite different and third category the kind of case where there is no issue about whether EU law takes effect in a particular territory, and there's no issue about whether standards or regulations are the same in a particular territory, but rather the issue is one of the application of EU law to a transaction between a member state to which EU law applies and one of the European territories associated with the member states, of which there are many. And within that third category, we can distinguish 2 types of cases. One is where the transaction is between a member state and its own territory, such as Jersey potatoes, the Gibraltar cases, and XBV. And the second subcategory would be cases where the transaction is between a member state and the territory associated with a different member state, such as Prunus, which concern the movement of capital between France and the British Virgin Islands. Now, as I've said, I don't for 1 minute suggest that this is an exhaustive categorization. There may be many more. But the basic point that I'm seeking to make by looking at cases in different categories, referring to different contexts, is that the question of the status of a particular territory arises in very different contexts, where the reasons for asking, is this territory a third country or not, may be very different. And because the reasons for asking that question are different, there will or there may be a different logic behind the answers. And so, although I would have thought that my second heading, context is everything, represented an uncontroversial proposition, perhaps it's not, because the intervener does try to read across from cases in different contexts to this context. And our submission is, there is no inevitable read across. The fact that Jersey may be treated as a third country for the purpose of, for example, regulatory standards and legislation on equivalence thereof, doesn't mean inevitably that it should be treated as a third country for the very different situation that we have here. And that is precisely the point that was made by the Advocate General in the paragraph that I showed you, paragraph 39 of Prunus, where the Advocate General emphasises that one has to look at the relevant legal framework. And that, in our submission, answers the point that my learned friend for the intervener has also made about cases like Commission in the UK and Van der Kooi. As I've said, they fall into my first category of cases concerning the territorial scope of EU law. But there's no dispute in this case about the territorial scope of EU law as such. There's no dispute that Article 56 did not apply in Jersey, and Article 63, as it is now, TFEU does not apply in Jersey. So this isn't a first category case, it's what I've called my third.
I'm having a little trouble at the moment following the structure of your argument. In a case like Jersey potatoes, for example, the court takes its starting point when it's asking, do the rules for free movement of goods apply to Jersey? And it finds the answer in looking at what the treaties say about Channel Islands and what the protocol to the UK's Act of Accession said about the protocol. Now, what's the structure of reasoning? What's the chain of logic in? Well, I was
actually going to come on to that, because my third heading is how does the court analyse cases falling into the third category? And I was going to take you to Jersey potatoes and show you the structure of the logic there. But my starting point under my second heading was that there are different cases that arise in different contexts. And my lord, we are within the third category of case when we're looking at transactions between a member state and an associated territory. And as I will show you, the answer to that has not turned on simply whether the relevant EU rule applies in that territory. That's part of the logic behind the answer, but it's not all of the logic behind the answer, because a major part of the logic in those cases has been to look at the relationship between the two territories, or the territory and the member state in question. Now,
so Article 50, you accept Article 56 doesn't apply to Jersey?
Yes, we accept that.
Would Article 56 apply to if Jersey were to impose restrictions on transactions involving the UK?
I wanted to just check the answer. The answer is no, it wouldn't, because Jersey is not bound by 56. Yeah. And that's why the question here is not about the territorial scope. The territorial scope was my first category. The question here isn't about the territorial scope of 56. We're all agreed that Article 56 does apply to the UK and does it apply to Jersey. The question is rather, in applying Article 56 to the UK, is Jersey, in the application of 56 to the UK, to be regarded as a third country? Or is it to be regarded as an internal situation where Article 56 simply is not triggered? Because as you will have seen, and is also common ground. There are categories of cases where if there is a wholly internal situation, the analysis of the court is that the relevant treaty freedom simply is not engaged. And the rationale behind that is that EU law does not bite on transactions or relations internally within a member state. And the conclusion of the court in Jersey Potatoes and the Gibraltar was that it was a wholly internal situation, so Article 56 simply didn't bite. But if I can just come to then my third heading, and that was how the court analyses this kind of third category case. And I've divided it into two subcategories, as you will have heard, transactions between a member state and its own territory and transactions between a member state and the territory associated with another member state. Now, it is common ground that if this had been a movement of capital from France to Jersey, the correct analysis would be to treat Jersey as a third country vis-à-vis France. And that's common ground, and that's the prunus situation. Jersey couldn't be regarded as a member state itself. It doesn't apply Article 56. And nor could it be regarded as an internal situation vis-à-vis France. So it would have to be regarded as a third country for those purposes, which was the prunus analysis. But because this transaction is between a member state and its own associated territory, our submission is that it should be regarded as an internal situation. And in Jersey Potatoes and Gibraltar, in both of those cases, the court found that there was a wholly internal situation. And the question is, what is there about this case that makes it different? Is the fact that Article 56 doesn't apply a sufficiently distinguishing and decisively distinguishing factor? And to that, we need to look at the analysis of the court in Jersey Potatoes and Gibraltar, and that's my fourth submission. And that is that the Jersey Potatoes and Gibraltar cases do not turn decisively and solely on the fact that in both of those cases the relevant provision of EU law applies. So this is my rebuttal of the intervener's submission. And if I could start with the Jersey Potatoes case, and that's at Bound Volume 2, and I hope that my answer to that will answer, my lord, your question, yes, or at least will begin to answer it. Yeah. Now,
can I just check, I've got it right. A movement of capital from Jersey to the UK falls within the scope of Article 56. A movement of capital from the UK to Jersey doesn't.
No. A movement of capital from Jersey to the UK, or let's put it in more legal terms, a restriction on a movement of capital from Jersey to the UK does not fall within Article 56 because Article 56 does not bind Jersey. Yeah. Jersey does not have to implement Article 56. On the other hand, we accept, and it's common ground, that it can benefit from the third country provisions of Article 56 in respect of a movement of capital from France, or a restriction on a movement of capital from France. I should maybe pause there and say this asymmetric effect only arises because of a peculiarity in the free movement of capital rules, that unlike the other freedoms, they extend to third countries. It's never been entirely clear what the rationale was. Some of the advocates general in some of the cases in the bound volumes do attempt an explanation, and I could just give you one reference, which is the Advocate General in Prunus at paragraph 21. So there are some explanations for it. They're not always consistent. But the fact is that for good or ill, with the entry into force of the Maastricht Treaty, we have what is now, what was Article 56 and is now Article 63, and that provided and provides for third countries to benefit from the liberalisation of capital movements, subject to some conditions and exemptions which are set out in what's now Article 64.1. But that, my lord, is the reason why one has an asymmetric situation, at least in our submission in relation to say, the France-Jersey situation. So in a France-Jersey situation, Jersey could impose a restriction on the movement of capital from Jersey, but it would benefit from the provisions of Article 56 in relation to France. Now, the question is whether that's the same for the UK, and in our submission it's not, because the UK is in the different position of being the member state for which Jersey is responsible. And if I can summarise our case in a nutshell, it's that Article 56 wouldn't bite on a restriction of moving capital from London to Edinburgh, and it also should not bite on a restriction on the movement of capital from London to Jersey.
But Edinburgh is within the United Kingdom.
Yes.
The question here is whether Jersey should be considered for this purpose.
Absolutely, and the starting point is the point that the Advocate General made in Prunus, that Jersey, as with many other territories, these associated overseas territories, is in a hybrid situation, and the question is, it's somewhere between a third country and a part of the member state. We know that there are some purposes for which it is regarded as a member state or part of the member state, and others for which it's not. And the question is, in this case, which side of the line it falls, which we say is a question that the court has not answered. So my fourth heading then, I was going to look at what the court said in Jersey Potatoes, and that's in volume 2, tab 24. And it's in the electronic bundle. It starts at page 982. The particular page that I wanted to take you to was page 1022 in the electronic bundle, and that's paragraphs 45 onwards in the bound volumes.
This is in the judgment.
Yes. And this is in the judgment, yes. Much as it would be fascinating to look at all of the Advocate Generals for all of these cases, we wouldn't be finishing this morning if I did so. But in the judgment, the court advances a series of reasons for its conclusion that the Channel Islands had to be treated as part of the UK for the purposes of the free movement of goods. And the first reason that it gives is that the relationship between the Channel Islands and the United Kingdom cannot be regarded as similar to those between two member states. And it then goes on to give other reasons, and I absolutely accept that among those other reasons are the point that the community rules apply to the Channel Islands and the Isle of Man under the same conditions as they applied to the United Kingdom. So that was absolutely part of the court's reasoning, and we do not try to avoid that. But my point is that the first reason given by the court was the close relationship between the Channel Islands and the United Kingdom. And the court makes that point in quite unequivocal terms, that because of other aspects of the status of those islands, relations between the two cannot be regarded as similar to those between two member states. So it's rejecting the proposition that there is a foreign element that would enable the treaty provisions on free movement to be engaged. And then at paragraph 54, the court says it's clear from all the preceding points that for the purposes of the application of these provisions, the Channel Islands, the Isle of Man and the United Kingdom must be treated as one member state. So while this we absolutely accept is in a slightly different legal context in which the relevant treaty freedom did apply, if that had been the only reason for the court's judgment, it wouldn't have needed to make the first point at all. If the decisive point had been the one made at paragraph 46, then paragraph 45 would have been entirely superfluous. And yet the court did put that as the relationship between the two, the Channel Islands and the UK, as its first point. And that scheme of analysis, that logic, was then confirmed explicitly in the Gibraltar case.
Paragraph 47 on page 1022 founds, obviously on protocol number 3 to the Act of Accession, and the provision there that the rules on, amongst other things, or customs matters and quantitative restrictions were to apply under the same conditions as they apply to the UK, and we're told that that suggests that for the purposes of those rules, the UK and the islands are to be regarded as a single member state.
Yes, absolutely. So that was, and I don't seek to avoid that conclusion.
No, what you're saying is they didn't need to have paragraph 45 if that was the only reason.
Absolutely.
That's what you're saying.
That was my submission.
It's for us to judge whether paragraph 45 is merely by way of preamble or whether in fact it is a part of the essential reasoning.
Yes, my lady, absolutely. And that is why I was going to take you to Gibraltar, which in my submission shows that it was not a merely preamble point. Now,
I mean, doesn't that go against your submission that it's all context driven? I mean, if paragraph 45 gave you the answer, then it would follow that the under the same conditions bit is OTOs.
Well, my submission is that paragraph 45 was a key element of the analysis, and in this case we have to decide whether paragraph 45 would be on its own essentially enough. And I would say it is enough, but it's enough when supplemented by some of the other matters to which I was going to take you to in the last of my 7 headings. Because I would say that it is not merely the case that in this case we're looking at the close relationship between the UK and Jersey, but we're also looking at a legal context where, although the free movement of capital doesn't apply in Jersey, we know that elsewhere under international law, for the purposes of liberalisation of capital movements, the UK is responsible for Jersey, and we know that the 2 territories are in monetary union. So there are, in our...
So it's 45 taken with other factors special to this case.
Absolutely.
It couldn't be 45 on its own because fairly clearly some cases they are a third country, some cases they're not.
That would be the high point of my submissions, but I'm not actually seeking to persuade you that 45 taken on its own is sufficient, because I am also relying on other factors concerning the free movement of capital in this case. So Gibraltar. Now, before I take you to the European Court judgment in Gibraltar, it's, I think, appropriate to start with a bit of a preamble. And the start of the preamble is the judgment of Mr. Justice Green, as he then was, in the first of the 2 Gibraltar judicial review cases. And that's in the same bundle, it's at tab 21. And the report starts at page 821. It's a long report, and I'm not going to go to very much of it. The reason for showing you this is simply because Mr. Justice Green concluded unhesitatingly in that case that if it had been decisive for his judgment, he would have referred the question, and it was by excellence a matter that should be referred to the CJU. And the question before him was the lawfulness of a new regime for regulating gambling operators based on the place of consumption of the services, which for the first time caught operators who were based in Gibraltar. And one of the many questions that arose in the judicial review was whether the relationship between Gibraltar and the UK should be regarded as an internal situation for the purposes of the free movement of services. And I just wanted to show you the paragraphs where he said that if he had needed to, he would have referred to the European Court, and those are paragraph 227 at page 909, where he said, had this issue been determinative of the outcome of the claim for judicial review, I would have referred this matter to the European Court. It's a matter of high constitutional importance and involves difficult questions of European law. And then he says much the same, paragraph 253, I acknowledge that this is a finely sorry, my lady, that's on the electronic bundle, that's page 918.
Thank you. I seem to be the only one who's using the electronic.
Who's ahead of the times.
No, I'm slightly behind the times.
I'm sure that's not the case.
So paragraph
253 at page 918. In the second half of the paragraph, I acknowledge that this is a finely balanced conclusion. So he expressed an obiter view because he said it's not determinative of the claim. I'm therefore not going to refer it, but I'm nevertheless going to express a view on it because it's been argued before me. His view was that relations between the UK and Gibraltar were to be treated as relations between a member state and a third country. So he thought that Gibraltar was a third country situation. And then he says, I acknowledge that this is a finely balanced conclusion, and this would have been par excellence a question for the Court of Justice. So he didn't refer it. As I'm now going to show you, when it was referred, the Court of Justice concluded the opposite.
This was before Prunus?
This was, I think it was after Prunus.
I think Prunus is cited.
Yeah, and indeed X is cited. So it was after. It was even after the X BV case, which I'm going to come to.
It's after Prunus.
Yes, it's 3 years.
He looked at pretty much all of the cases that we have cited to you today. And having looked at all of those, not only the Prunus and X, but also the Jersey cases, he concluded that Gibraltar was in a third country situation, but he didn't need to refer it, although he would have referred it if it had been decisive. Then there was a second judicial review, and I don't need to take you to the domestic court. What happened there was that there was another judicial review concerning a slightly different point, which was the new tax regime applicable to remote gambling. And in that case, again, the question about the internal situation or otherwise of Gibraltar was raised. And Mr. Justice Charles said, I do need to decide this, and I agree with Mr. Justice Green in the first Gibraltar judicial review that this should be referred. He therefore made the reference, and that was the reference that gave rise to the judgment that is now in the third of the bound volumes at tab 35, and that starts at paragraph 1429. And as I've just said, the court found the opposite to Mr. Justice Green's obiter conclusion. It decided that this was a wholly internal situation. And I wanted to show you the reasoning for that, because that reiterates the logic in Jersey potatoes, and in an interesting way. At paragraph 37 of the Gibraltar case, at page 1453 of the electronic bundle, the court started by looking at the Jersey potatoes case, and it explained what it thought the rationale was, and it said the court relied in particular on the fact that EU rules on customs matters are to apply in the Channel Islands and to the Isle of Man under the same conditions as they apply to the UK, and on the fact that no aspect of the status of those islands suggests that relations are akin to those between member states. So the court is saying there were two bases for the decision in Jersey potatoes, and those were the two. And they then went on to apply the same schematic framework to the situation of Gibraltar. So first considering whether the freedom to provide services applied to Gibraltar, and that's the first point. And then at paragraph 41 onwards, the relationship between Gibraltar and the United Kingdom. And in the course of that second point, the following very unequivocal statement is made at paragraph 42 on page 1454, to treat trade between Gibraltar and the United Kingdom in the same way as trade between member states would be tantamount to denying the connection between that territory and that member state. It's common ground in that regard that it is the United Kingdom that has assumed obligations towards the other member states under the treaties, so far as the application and transposition of EU law in the territory of Gibraltar is concerned. So going back to my Lady Hale's point, had the court considered that the first of its 2 points was decisive and solely dispositive of the question, as in, had the court considered that the only answer that needed to be given was that Gibraltar applied the free movement of services.
It wouldn't have had to say what it says in 41 and 42.
Exactly. And 42 is expressed in no uncertain terms. And then the conclusion at paragraph 43, it follows that, must be taken as referring to both of the two limbs of the argument. And it is notable that in neither of those two cases did the court adopt the principle that is set out by an intervener that a territory is treated as part of its associated member state where EU law applies to it, but otherwise treated as a third country. That legal framework is simply nowhere to be found in either of these cases. So, as we were discussing a short while ago, the question for today's purposes is whether the first part of the reasoning in Jersey Potatoes and the second part of the reasoning in the Gibraltar case is sufficient when taken with the other factors that we've referred to in our written case, such that the same conclusion should apply here, or at least for the purposes of a reference, whether the position is sufficiently unclear and open to doubt that a reference should be made. And that leads me to my fifth point, which is the ex-BV case. And again, before looking at what the European Court said, it's helpful to start with a preamble by looking at what had happened in the Dutch courts. And we can get this from a translation of the opinion of the Dutch Advocate General, Mr. Wattel, which is at the sixth bound volume, tab 71, or page 2305 in the electronic bundle. My learned friend for the intervener has asked us how the translation was produced, so I should just say this was sent out to HMRC Translation Services, and it appears that this was a translation produced by a person as opposed to produced by a machine, or at least it wasn't solely produced by a machine. I should just clarify that because I have been asked the question. My learned friend may have some issues with the translation. I don't know what they are, but I think the sections that I want to refer to are tolerably clear.
There wasn't a Dutch version. They quite often
there is a Dutch version, and it's behind.
No, an English version produced by the Dutch court.
No, there wasn't. No. And this was, of course, only the Advocate General's opinion, yes, because what the court did. and one gleans from the Advocate General's opinion that the first instance court apparently decided the case on the basis of that even if Article 56 did apply, the legislation was permissible under the standstill in Article 57. Then the case went to the Amsterdam Court of Appeal, and it agreed with the result but gave different reasonings. It considered that the case concerned a wholly internal situation, and you can see that on page 2308 of the electronic bundle. It's paragraph 4.10. And the the Amsterdam court thought that this was wholly internal, with the result that neither Article 56 nor the OCT decision, both of which were being relied on in that case, applied. And in the Supreme Court, it referred the case to the European Court. But before doing so, Mr. Wattel, its Advocate General, gave an opinion in which he said that he agreed with the Amsterdam Court, and he thought that this was a wholly internal situation. And just for the court's note, that the section addressing this really starts on page 2315. And he says at paragraph 2.11, a point that I've already made. In the Prunus case, neither the Advocate General nor the ECJ discussed the relation that is important in our cases, that is, the relation between a member state and their own OCT. In my opinion, Prunus does not shed any light on this, and I therefore do not see any reason after this judgment to see a movement between the Netherlands and the Antilles as a cross-border case. I see an internal situation. In my opinion, it's difficult to see that the member state, the Netherlands, under EU legislation, is free to hinder an internal movement of capital from Amsterdam to Amersfoort, and would not be free to hinder the same and equally internal movement from Amsterdam to Curaçao. And then he goes on to refer to his conclusion, his opinion in a previous case. And then in the following paragraph and over the page, he cites an academic commentary, which I think was which was a commentary on that conclusion in the previous case, by somebody called Mr. Gerson. And over the page on page 12, the commentary makes the point that it's although it might be odd that OCTs regarding their parent state are in an internal situation, whereas for other member states, they are in a third country situation. That isn't necessarily odd, because one shouldn't assume that there is symmetry in that regard. And the commentator...
Which paragraph are you reading?
That's paragraph 12 on page 2316. And this is an extract from an academic commentary, which seems to have been a commentary on the previous opinion given by the Advocate General Wattle in another case in the Dutch courts. And the commentator says at the end of paragraph 12 of, I believe, the article, both statuses can exist next to each other, and gives the example of Germany and trade in goods between the former GDR and the FRG being identified as domestic trade, whilst the GDR remained a third country with respect to the other member states. And I don't need to say why that kind of analysis may have significant relevance for future political events if it were to be adopted in this case. So that was the Dutch courts, Advocate General Wattle basically putting forward the proposition for which the Revenue is arguing in this case, and the question then went to the European Court on a reference from the Dutch Supreme Court. And that's back to the main authorities bundles. It's bundle 3 at tab 34. And I think it's worth, and my lady, if you want to, it's page 1406 of the electronic bundle, and we will start on that page, because I do think it's worth picking up the headnote in this case, because the headnote summarises the question and at little h, and says this: the questions referred asked, in essence, whether the EU rules on the free movement of capital, such as Article 56 EC, had to be interpreted as precluding a measure of a member state which was likely to hinder movements of capital between that member state and its own overseas countries and territories. And if you replace the reference to OCTs with a reference to Jersey, it would be the identical question to the one that you have before you in my draft, although I have added at the end, or is this an wholly internal situation? I picked that question from this case. I've attempted to draft it in terms similar to the way that the court framed the question in this case. And what is interesting is that Advocate General Jeskinen thought that there was no difference between the situation involving a member state's own OCT and a dispute involving another OCT. And you get that at page 28 of his opinion, at page 1413 of the electronic bundle. And he went on to conclude that the OCT decision was not applicable to this case, and that the question was therefore governed in principle by Article 56. And he did so after quite a lengthy analysis of whether the OCT decision, that it's a specific decision that applies to the various OCTs, whether that was lex specialis, such that it didn't entirely exclude the other provisions of the treaty, or whether it actually displaced all of the other provisions of the treaty. And he thought it didn't displace the other treaty provisions. So if the OCT decision didn't apply, then one can then fall back on Article 56. And he then concluded that, looking at Article 56, at paragraph 48, he concluded that movements of capital between the Netherlands and the Netherlands Antilles do not represent a purely internal situation. So that was his analysis. But what is interesting for today's purposes is that the court took a completely different view. And the court thought that the OCT decision was applicable to the issue, and that the tax in question fell within a carve-out in that decision. And you get that on page 1427 of the electronic bundle. And it's really the whole page, but the most important paragraphs are probably paragraphs 51 to 53. And the court agreed with the United Kingdom government that the OCT decision included a tax carve-out clause. The court thought that tax carve-out applied in the present case, so that the particular disputed tax in that case was within the carve-out. The Netherlands was permitted to apply that particular tax, provided it pursued the objective in an effective and proportionate manner. And it was therefore not necessary to examine the internal situation question, or the third country question, however you frame it. In a way, the court did very much like what the Court of Appeal did in this case, which was to say, on the basis that the relevant rules were justified under a particular provision, or provided that they were objective and justified under a particular provision, it was not necessary to look at the question of whether this was a wholly internal situation. So the court was then leaving open the question as to whether, in principle, such a capital movement did constitute a wholly internal situation. It didn't ask the very question. It didn't answer the very question that it was asked. Now, the intervener puts forward several arguments to try and distinguish this case. And the first is that it is said that this case is not relevant because it's about an OCT which was subject to a specific regime under the OCT decision. And we clearly accept that this case did ultimately, the court found, turn on the fact that there was an OCT decision which was lex specialis. And we're not saying that in that respect that the Channel Islands are in legal terms on all fours with the position of the OCTs. What we are saying is that the position of the OCTs is related in a relevant way to the position of Jersey, in that both the OCTs and Jersey are European territories associated with member states that have a kind of hybrid status. They are third countries for some purposes and not for others. And hybrid in another sense, in that some EU rules apply to them but others do not. And relevantly in this case, Article 56 does not apply to the OCTs. That was a point made by the court. And that is the same as this case. And that was the reason why that question arose in that case. And it was a question that hadn't been answered before. And as I've shown you, despite the different context, the basic question asked by the referring court was essentially the same as the one that we're asking you to refer. And the court did not say, oh, well, that question's already been answered in Prunus, or it's clear from Jersey potatoes and Gibraltar that that question can be answered in a particular way. It didn't say that. It left the question wide open and said it wasn't necessary to answer it. The other point made by the intervener in their written case is that if the court had considered that this was a wholly internal situation, then it could have ruled on that basis. Now, that may be correct. It may be that an alternative way through might have been for the court to say that there was an internal situation such that neither the OCT decision nor Article 56 applied, which was the route chosen by the Amsterdam Court of Appeal. But the court chose to avoid ruling on that question by saying that the relevant provision was the OCT decision and that the legislation fell within the carve-out in that decision. And that rather supports our case because it indicates that the court had deliberately chosen an analysis that enabled it to avoid answering the rather difficult constitutional question regarding the application of the EU rules to a transaction between a member state and its own associated territory. And so, if anything, that point that the court might have been able to answer it by looking at the question that had actually been asked, but didn't, supports our submission that the position isn't clear and should be referred. So that then leads to my sixth heading, which is that all of this, and particularly the court's avoidance of the question in X, indicates that the appropriate course is a reference in this case. And I don't really need to dwell on that any further. My seventh heading is what this court should do if it were possible to decide for yourself. And as I've said, that still feeds into the question of whether a reference should be made, because in our submission it goes to whether there is any merit in the submissions that this is all that clear against me. If this court were to decide the question, you would need to consider, on the basis of general principles, because there is no precedent, whether you agree with the Dutch courts, that the Amsterdam Court of Appeal, that a situation such as this should be regarded as an internal one, or whether you consider that the situation of Jersey vis-à-vis the UK is a third country situation more akin to that of, say, Argentina or Kazakhstan. And if that's the question, in our submission, the answer is a fairly clear one.
Why did you choose Kazakhstan?
No particular purpose than I was looking for different letters of the alphabet. For the purposes of international law, one can pick any particular third country there, but our submission is this, and it's not a frivolous one. For the purposes of international law, Jersey is part of the same international entity as the UK, because it's one of the territories for which the UK is responsible under international law. And for that reason, for the purpose of other international agreements concerning the movement of capital, Jersey is regarded as part of the UK territories. As we've said in our written case, it's party through the UK to the OECD codes of liberalisation of capital movements and current invisible operations. And that was the case before the Maastricht Treaty came into force, which introduced the third country provision in the free movement of capital in Article 56. So the effect of the intervener's submission would be that the enactment of the Maastricht Treaty fundamentally altered what was otherwise the international legal relationship between the UK and Jersey for these purposes. And it altered it from a situation where Jersey was regarded as part of the same international legal entity as the UK to one in which, on the intervener's case, it should be regarded as a third country vis-à-vis the UK for the purpose of capital movements.
But what is the overlap between the OECD regime and the EU regime in this regard?
Well, I don't think it's necessary to delve into which provisions are similar, but the OECD in broad terms, the OECD regime in broad terms addresses the liberalisation of capital movements. It obviously doesn't go as far as the provisions of the EU rules.
But I'm just trying to get a handle on what the OECD treats the Channel Islands as will assist understanding what the EU law provision is.
So it's really a contextual point that in relation to international rules concerning the liberalisation of capital movements, such as the OECD rules, Jersey is treated as part of the UK because it's part of the same international legal entity as the UK. It doesn't have sovereign status. And we've set out in our written case the way in which Jersey can participate in international agreements, either effectively through extension of those by the UK to the territory of Jersey or kind of delegated powers.
But this is a contextual point
point
to assist interpreting what EU law is, presumably.
Well,
or if not, why are we hearing about it?
It is a contextual point to illustrate the framework point and the point about deciding it not only in terms of the fact of the close relationship under EU law between Jersey and the UK, but also going back to my submission, it's not just the paragraph 45 point, it's the paragraph 45 point in circumstances where, for other purposes, there is a close relationship between Jersey and the UK for the free movement of capital, and that's really the extent to which the point goes.
Thank you.
And these are all contextual points. One of the other contextual points is that Jersey and the UK are in monetary union, and they share a single official currency. And according to repeated pronouncements, the States of Jersey has said that Jersey enjoys freedom of movement of capital, people, and trade in goods and services with the UK. So this is a particularly close relationship between the UK and that territory, which in our submission underlines and gives emphasis to what we might call the paragraph 45 point in Jersey potatoes, or the second of the two limbs of the argument in Jersey in the Gibraltar case. And in view of all of those contextual factors, our submission is that treating Jersey as a third country would not only be very odd, but it would, as exactly as the court said in relation to Gibraltar in paragraph 42 of its judgment, it would be tantamount to denying the connection between that territory and the UK, and it would be tantamount to denying the fact that the UK has assumed obligations under the treaties as regards the application of EU law in Jersey and the other Channel Islands. In our submission, paragraph 42 in the Gibraltar case could simply be lifted and transposed to this situation because it's exactly the same point. My lady and my lords, that was our submissions on the third country point, and I apologise for going a little bit over what I had predicted to be my time on that, but I had sought to answer questions from your ladyship and your lordships along the way.
Well, thank you very much.
My lady, if it pleases the court, I'm going to address you next on this issue. I appear on behalf of the Attorney General for Jersey. Just as a preliminary point, I should say that that Jersey would take great exception to the suggestion that it is in any way a territory that belongs to the UK, or the cognate expressions used by my learned friend just now. For example, she referred to our territory. She referred to the United Kingdom as the parent member state of Jersey. All of those types of expressions portray an inaccurate position of the long-held constitutional freedoms that Jersey has and the independence that it has saved through the person of the sovereign.
Your position is that the position set out in Berkeley is an accurate statement, is that right? Or am I wrong about that?
My lord, yes. Berkeley is a exposition of the constitutional position. I've summarised it in my own words in my written case, but Berkeley is also perfectly accurate. The essential propositions of my case, and I think I'm going to be quite brief, are that the territorial application of provisions of EU law must be a matter of certainty, that in relation to Article 56 that we're considering here, there is no other solution other than that the territory in question must be either a member state or a third country. So I accept that in relation to the territories known as the OCTs, because of the OCT decision, in their particular cases there may be additional wrinkles, but Prunus in particular, I'll show you, shows that there's no alternative answer, so that third country is cognate with any territory outside the member states, outside the European Union. I then submit that the jurisprudence of the Court of Justice has developed the approach over a number of cases, which in my submission is only logical, that the question of whether or not a particular territory is a member state or a third country for the purposes of any particular provision of EU law is to be determined by reference to the rules on whether that provision of EU law applies in that territory. And that is the distinguishing criterion. I accept that the judgments about this, as Ms. Bacon has indicated, sometimes as a preamble or as a discursive point, sort of set the background by reference to various other matters. In each case, my answer to that would be that is introductory worthy and is perhaps an explanation of why the position is that the particular provision of EU law applies to that member state or does not apply. So it's an explanation, but it doesn't answer the question. And the question is to be answered simply by looking at whether the provision applies or not. I would make that good. And a particular example of this can be seen in the various cases concerning Gibraltar, where opposing conclusions have been reached on different provisions of EU law. So in particular, the cases I have in mind are the 2001 case commissioned in the UK, where the conclusion was that Gibraltar is a third country for those purposes, and in contrast, the Gibraltar betting case, where the conclusion is that Gibraltar is part of a member state for the purposes of the legislation in question there. And so that clearly demonstrates that you can have both answers in the case of the same territory, and as I say, the distinguishing criterion is whether or not the provision of EU law applies in that territory. So those are my essential propositions. I think that I should make one or two further background points. So there's no dispute, as the Revenue have acknowledged, that Article 63 would be of potential application if it's established that Jersey is a third country for these purposes. There's also no dispute that Jersey itself is not obliged in its legislation to comply with Article 63. And that is consistent with the provisions or the position for other third countries. So, for example, the United States is not required to comply with Article 63 plainly, but there isn't any requirement for reciprocity. So Article 63 applies with full force to transactions between a member state and the United States, regardless of what the United States' position is. So in the same way, it doesn't matter that Article 63 is not to be applied in the laws of Jersey, in my submission, it still applies to govern transfers between member states, and in particular, it still applies to prevent member states from restricting movement of capital in the way, in any way that contravenes Article 63. So, my learned friends refer to that as an asymmetric effect. In my submission, that asymmetric effect is a necessary consequence of the way Article 63 works in relation to third countries and is prevalent in relation to all third countries. Now, my learned friend's case, the revenues case, then involves further asymmetries, and in particular, she suggests that the position should be different as between movements of capital between France and Jersey, and as between movements of capital between the United Kingdom and Jersey. And in my submission, there's no logical basis for that. There's no provision in the treaty that requires that. There's nothing in any judgment of the Court of Justice which requires that. And there's nothing in any Advocate General's opinion at Court of Justice level that requires that. The only judgment which the Revenue have identified as supporting their case is the opinion of the Dutch National Court. And in my submission, you should attach no weight to that whatsoever, in particular because the opinion is not binding on the Dutch National Court, and the Dutch National Court, in fact, didn't follow it. It referred the question to Europe, and so the question, in effect, anything said there is trumped by what the European Court said in that same case. In terms of the authorities, I've identified in paragraph 22 of my written case 5 authorities. And I think it might be helpful if I simply summarise what the position was in each of them, that perhaps is, in my mind, in the form of a table. So, Van der Kooi was a case concerning VAT, and the 2 territories in question there were the Netherlands Antilles and the Netherlands. So it was about a boat imported into the Netherlands. And the answer in the case was that, for those purposes, the Netherlands Antilles were a third country.
Sorry, I didn't hear.
We're a third country.
Could I ask you to speak up a bit?
I'm so sorry.
Those things don't actually amplify what you say.
Yes.
They're there for the purpose of transmission around the world. But in order to be heard in this room, you need to speak up.
I shall do so, my lady.
you.
I do apologise. My dulcet tones plainly are not making the points I want to make.
This is true. But it is the first duty of any advocate to be heard.
My lady, I was saying in Van der Kooi,
Yes.
it's a case concerning VAT, concerns a movement between the Netherlands Antilles and the Netherlands. Mr. Van der Kooi moved a boat into the Netherlands and then lived in it in a Dutch port. And the answer in the case was that the Netherlands Antilles, for that purpose, were a third country. Commission and UK is a case about the customs union, in other words, movements of goods. It concerned the general position in relation to movements between Gibraltar and any member state. And the answer in that case was Gibraltar was a third country for the purposes of movement of goods rules. Liga Portuguesa...
Sorry, just to ask, just to understand in a sentence, the reasoning, was that because the Act of Accession dealt expressly with free movement of goods, or what?
So the position in relation to Gibraltar is that generally the EU law does apply in Gibraltar, save in relation to movement of goods.
Yes, yes.
And the reason for that is set out in...
I wasn't wanting necessarily to go to the case, it was
Yes.
just to understand what the rationale was. And
my Lord, the rationale was that before then, Gibraltar had essentially been a sort of duty-free area, and I think Gibraltar was presumably precious about losing that particular status. So, in other words, goods can be imported from outside Europe into Gibraltar freely or subject to Gibraltar's own rules.
But that was covered by the Act of Accession, was it?
Well, in effect, there was then an exclusion of Gibraltar from the customs union, and it's explained. It's explained, I think, best in paragraphs 39 and 40 to the judgment. If I may, I'll come back to that.
And in the Van der Kooi case, was that was the rationale there that the VAT directives didn't apply to the Dutch Antilles?
My Lord, yes, it was about the VAT directives as opposed to the treaty, but in my submission, it's self-evident that it would be extraordinarily unlikely if there were a different answer to the question of whether a particular territory is a third country for a particular directive as opposed to the treaty. I mean, there would need to be a very sound logical basis for that.
Yeah.
I'm citing these cases more for the analysis. In particular, I look for words like that show what the court's real reasoning is.
Yes, well, that's what I was trying to
That's what
understand.
you were trying to get at, yes.
Just telling us what the outcome of a case is isn't in itself as helpful as knowing, in a sentence anyway, why the court arrived at that outcome.
My Lord, indeed, my Lord. But I thought it might be helpful still to have a sort of a general table as to what the position is in each of these, just because we're going to go back to them shortly.
Going back to C and UK for a moment, am I right in thinking that that was concerned with the relations of Gibraltar and any member state, including the United Kingdom?
Well, my Lord, there's no exclusion of the United Kingdom from the discussion of the court in that case. So it doesn't expressly say either this includes the United Kingdom or this doesn't, but it simply talks in terms of the member states.
Said Gibraltar should be treated as a third country for the movement of goods.
Well, my Lord, it must follow from the court's reasoning in that case. I mean, it would be an extraordinary omission if they didn't refer to the United Kingdom in it.
Thank
you. Just to complete the table, so Prunus is a transaction between the British Virgin Islands and France. Effectively, in that case, it was looking back to the capital movements when the company was originally set up. It's a free movement of capital case. Answer third country. And Gibraltar Gaming and Betting Association, again, it's a Gibraltar case, and there it concerns the freedom of establishment. So freedom of establishment, plainly a provision which does apply in Gibraltar. Outcome, Gibraltar was a member state for that purpose. So if I can perhaps come back to some of these cases in more detail, I'm not going to rely in detail on Liga Portuguesa. That's simply a throwaway passing comment in that case, that the betting website in that question was in Gibraltar, but it doesn't really add anything to the other authorities. So Van der Kooi,
So are all the decisions consistent with the proposition that if a given provision of EU law applies to a given territory, then that territory is treated as part of a member state for the purposes of that provision?
For that purpose, indeed so, my Lord, quite exactly as your Lordship's put it. So in Van der Kooi, we see in paragraph 22.
What's the page?
My Lord, 2219.
Sorry,
yes, we'll be working.
I'm so sorry. It's tab 67 in volume 5 of the authorities.
Yes.
And it's page 221.
Lord Carnwath and I are working exclusively electronically for everything other than the core authorities.
Yes, you've got three different propositions here. You've got me, who works on all authorities electronically. You have got Lords Reid and Lloyd-Jones, who work non-electronically on all authorities, and you've got an intermediate case with Lords Carnwath and Hodge, who are taking the core volume authorities electronically, but the core volume in paper and the rest electronic.
My lady, I'm extremely grateful. I shall endeavour to give all the references.
Two
If I
references,
fail
please.
to, please do pick me up,
Thank you.
and I shall try to. So this is volume 5, tab 67. It's page 2219.
2219. Thank you.
So, my lady, my lords, you'll see at paragraph 22, it simply states the background. In other words, that the issue was whether the vessel had been imported into the Netherlands. And if some goods are imported, there's VAT at the point of entry. So that's why the issue arose. And as you may be anticipating, that this case is particularly significant in the light of HMRC's submissions about the XBV case, because they say in XBV that every transaction between the Netherlands Antilles and the Netherlands must be an internal situation. And this case shows in my submission perfectly plainly that their submission is wrong on that. So the question the court was examining was whether in paragraph 32, that's page 2221, whether the entry into a member state of goods coming from the Netherlands Antilles is entry into the community. And in my submission, if it was an internal situation, it would be quite impossible to say that a movement from the Netherlands Antilles to the Netherlands is an internal situation, is an entry into the community, because it would be an internal situation in the same way as, for example, perhaps a better example than Ernest's friends give, a movement of goods from Northern Ireland to Scotland or England would be an internal situation as a customs matter. Although it's coming through a port, it's internal because Northern Ireland is part of the United Kingdom. So that's not, the court concludes in paragraph 38 on page 2222, the entry into a member state, and particularly there, the Netherlands, of goods coming from the Netherlands Antilles cannot be regarded as an intra-community transaction. And then they say, I accept they say unless there's some special provision otherwise, but they go on in the very next paragraph to say there is no special provision otherwise. So they do consider in paragraph 39 whether there might be a special position for OCTs in relation to movement of goods, but they find none. So that's Van der Kooi. The Commission in the United Kingdom in 2001 is in the same hard copy volume. The passages that I rely on are on page 2052 on the memory stick. So on page 2052, we're still in submissions of the parties, but there's helpful explanation here of how the position arose. So although Gibraltar, in paragraph 39, although Gibraltar was no longer to have the status of a third country as a result of the accession of the United Kingdom to the EEC Treaty, which from then on applied to Gibraltar, I see those as crucial words in that sentence, its position remained comparable to that of a third country in respect of trade in goods, both with member states and with third countries. And then in paragraph 42, it's clear from those provisions that although Gibraltar is no longer included on the list of third countries, and it gives the regulation, its position as regards access to the markets remains the same as it was before accession. Then over the page 2054, paragraph 47, we have the reasoning of the court. And paragraph 48, it must be considered whether the directives at issue are applicable to Gibraltar. So that, in other words, the decision as to whether or not Gibraltar is within or outside the EU based on whether the directives at issue are applicable to Gibraltar. There's effectively legal background over the following paragraphs. Your Lordships will see at paragraph 51, the customs union it concerns effectively charges at the external frontiers of the community by products imported from non-member countries. Paragraph 55, page 2056. Products originating in Gibraltar are not products originating in the community. And then 59, page 2057, it's clear from all the foregoing that the exclusion of Gibraltar from the customs territory implies that the treaty rules on free movement of goods, etc., are not applicable to it. So, my submission that there is an inexorable logic there, and it is in line with the submissions I've made. The Prunus case, this is in the core authorities. It's volume 3, tab 30, page, I'm going to start on page 1261 on the memory stick.
Sorry, could you repeat that, please?
Page 1261.
Thank you.
So the first, there are 2 points which I derive from Prunus, and the first is the point that Article 63, when it refers to third countries, is referring to anywhere outside the territory of the European Union. So that is derived from, in particular, paragraph 20 on page 1261. So Article 63 prohibits all restrictions on movement of capital between member states and third countries. In view of the unlimited territorial scope of that provision, it must be regarded as necessarily applying to movements of capital to and from OCTs. Bearing in mind that this predates the OCT decision, or the facts in issue predate the OCT decision.
Your voice is falling again.
I'm so sorry. This predates the OCT decision,
yes.
And therefore there's no express reference to the OCT decision in that particular context.
Thank you.
Now, but when the application of Article 63 to movements to third countries was introduced, that's to say by the Maastricht Treaty with effect from the 1st of January 1994, at the same time there was a grandfathering provision which is now to be found in Article 64 of the Treaty on the Function of the European Union. Previously that was Article 57 of the EC Treaty. So the grandfathering provision protects member states' restrictions that they had in place as regards third countries prior to the 1st of January 1994, subject to certain conditions. And so the question that the court then examines in the Prunus case is the BVI a third country so that the grandfathering provision is in issue? And they're going to conclude that the BVI is a third country for that purpose. So the reasoning on this starts at paragraph 28, page 1262. So it's necessary to determine whether OCTs are to be treated as member states or non-member states. Paragraph 30, the EU treaties do not contain any express reference to movements of capital between member states and the OCTs. In other words, there isn't well, there isn't any, I suppose, lex specialis for them, subject to the OCT decision. Paragraph 31, it follows that OCTs benefit from the liberalisation of the movement of capital provided for in Article 63 in their capacity as non-member states. Now, in my submission, the reference to in their capacity as is a recognition that for some other purposes they could be treated as member states in a similar way to the Jersey potatoes case and some of the Gibraltar cases, etc. Now, in the Gibraltar gaming case, this is in the this is also in the Primary Authorities, Volume 3, tab 35.
Page.
I rely on, first of all, the Advocate General's opinion starting at 1438.
1438, thank you.
So, in essence, my lady, there's a summary in the Advocate General's opinion here of the authorities which we've already looked at. But in my submission, it's a helpful summary, particularly for the analysis of that he gives of the court's reasoning. So, in 35, he's discussing the other Gibraltar case, Commission in UK, and he says that the outcome in that case, that Gibraltar is not part of the customs union, is in his view a logical conclusion I perhaps put that a little bit wrong. The fact that the free movement of goods rules do not apply in relation to Gibraltar is a logical conclusion from the fact that as a matter of law, Gibraltar is not within the customs union. That's the accurate position. So, plainly, in this particular case, the Advocate General and the court are looking for reasoning that leads to the outcome that Gibraltar, in this case, concerning freedom of establishment, is within a member state. And you'll see that in relation to that, at paragraph 37, he starts with some reasoning which the court then followed, that one of the relevant factors is how would you deal with infringement if there's an infringement of, let's say, the free movement of establishment in this particular context. So if you wanted a commission and a territory case, you couldn't have a commission and Gibraltar case. You'd have to have commission and a member state. And the only logical member state in relation to the provisions which do apply in Gibraltar would be the United Kingdom. So we have no dispute with that as a proposition. That again follows from the inherent logic of the case which I'm advancing. But of course it would not apply in relation to provisions which don't apply in those member states. Now, then there's analysis of the Gibraltar, the Jersey potatoes case, and you'll see that paragraphs 48, 49 of the Advocate General. I think that's useful reasoning. Then, in the judgment of the court, paragraph 37 on page 1453, so the court here, looking at the Jersey potatoes case, says that the conclusion, in reaching its conclusion, the court relied in particular on the fact that under the protocol to the Treaty of Accession, EU rules on customs matters applied under the same conditions as they apply to the United Kingdom. And then in the analysis in paragraphs 39 to 42, which my learned friend has relied on, I say that analysis is perfectly apt in the circumstances of the Gibraltar case, because they're looking there at freedom of establishment rules, and those as is expressed in paragraph 39, freedom to provide services as well, those which are expressed in paragraph 39 are applicable in Gibraltar, but then it follows, all the rest of it follows. And as I said earlier, once a territory is within the EU, as a matter of Article 355 of the treaty there, Article 299 of the treaty we have here, once the territory is within the EU, then you need to be able to identify which member state it's within and which member state would be responsible for any infraction.
Once it's within the EU for the particular purpose?
For the purpose, my lord, indeed, precisely so. So, in relation to XBV, is the final authority that I'm going to look at. So XBV is in the primary authority, is the same volume, volume 3. I want to look at page 1418. So we've already looked at the judgment and seen that the court didn't answer the question, but the Advocate General did analyse the question and answer it. And the answer is in paragraph 48 of the Advocate General's opinion. And in effect, what's said here is that because the two territories have a different status with regard to the applicability of EU law, that does not represent a purely internal situation. And I adopt that as a very neat expression of the principles which I'm advancing. My lady, you will have seen...
I'm sorry, just before you proceed, can I just check I'm following? So, in the Gibraltar case we just looked at, Article 56 was applicable to Gibraltar.
My lord, I should say Article 56 there was Article 56 of the Treaty for Functioning of the European Union.
Oh, of course.
So
right.
it's about freedom...
Not Article 63.
Freedom to provide services. In that
I'm getting confused with the numbers.
I think 49.
Easily.
Yes.
Yes.
Yeah. So it was about freedom for services. Yeah.
Yes.
Right.
But my lord, it's quite right that also the free movement of capital provision would apply.
It's just the customs union and free movement of goods which is excluded.
Precisely.
Yes. Everything else applies in Gibraltar.
Precisely.
Yes.
Yes, so it's really the critical distinction is that whereas under Article 355 everything applies to Gibraltar subject to a few exceptions, nothing applies to Channel Islands except for some exceptions.
My lord, quite so, and I suggested in my written case that they're the mirror image of each other.
Yes, I follow.
But I mean, we don't rely on the mirror image point as such. What we rely on is the underlying logic in all of these judgments. You'll have appreciated that. So my next point is that in my written case, I refer to the position under some other provisions of EU law. The one I would like to particularly draw the court's attention to is the data protection regulation. This is in the additional authorities, tab 43, page 1538.
Sorry, which volume?
My lord, it's volume 4, tab 43. So the context of this is explained in my written case. There's a data protection directive and regulations which prohibit transfers of data to third countries unless those third countries meet specific criteria and satisfy the Commission that they meet those criteria. So the list of countries, third countries, which have satisfied the Commission that they meet the criteria is quite a short list. So this is the decision which effectively acknowledges that Jersey is a third country which has met those criteria. And in the preamble to this, you will see on the right-hand column at paragraph 5, this paragraph, the bailiwick of Jersey is one of the dependencies of the British Crown, being neither part of the United Kingdom nor a colony, that enjoys full independence except for international relations, which are the responsibility of the United Kingdom. The bailiwick of Jersey is therefore to be considered as a third country within the meaning of Directive 95/46.
That was the former data protection.
Precisely,
yes.
Precisely. And I think the position is, but I don't pretend to be an expert on data protection, I think the position is that this decision is still applicable as indicating that Jersey meets the relevant criteria. I rely in particular on the word therefore there. Why did they say therefore? And of course, there isn't the full analysis that we have in this case, but that does plainly act as a contrary indication to HMRC's case that the fact that the United Kingdom is responsible for Jersey's international relations makes Jersey part of the United Kingdom. Now, it is true that the United Kingdom is responsible for Jersey's international relations. In the particular context here, that function, in my submission, was spent when the 1972 treaty became part of the international law. In other words, the United Kingdom at that time must have negotiated Protocol 3 that covered the Channel Islands as well. And that is an example of the responsibility for international relations. But once that treaty is in place, then the treaty governs the position. And the United Kingdom can't come along later and say, because we're responsible for this, we're the only people who are capable of interpreting it correctly. Now, I appreciate that there's an unattractive position here where, in effect, you have two governments, both under the British sovereign, which are arguing the contrary sides in a case. It is not...
Well, it wouldn't be the first time. They did in Berkeley.
In our submission, it is solely the revenue's position here. It's not part of the wider view of the United Kingdom government. My client has attempted to engage with the revenue on this through proper channels. There was a meeting at the Ministry of Justice before the Court of Appeal, hearing to see if the position could be resolved without a dispute in court. But the difficulty is that the revenue have taken this view. They've taken the view in another case concerning the Isle of Man, which we don't need to be troubled with. And it's an argument that the revenue want to have a ruling on. The position in relation to international relations is a little bit nuanced than is suggested here. In other words, the actual position these days is that Jersey participates in international agreements with its own agreement, so it will be asked for its position on a particular thing, and for some international matters, Jersey would negotiate its own position itself. If you like, with a delegated authority from the United Kingdom, if there's a question of authority. But there's considerable autonomy, in fact, in the 21st century. Going back to this decision about data protection, to the extent that this passed through EU processes, I would assume that the United Kingdom must have not only been aware of it at the time, but must have participated in that process on the basis that the United Kingdom is responsible for the external relations. So I can't believe that the United Kingdom disagrees with what's said in paragraph 5 in this preamble, and there's been no suggestion from the other side that they do disagree with that. My learned friend has relied, in passing, I would say, on what she calls currency union between Jersey and the United Kingdom. It's regrettable that this was advanced only for the first time in this court. There's no evidence on what the currency position is, but I submit on instructions that there are material inaccuracies in HMRC's portrayal of the position. Specifically, the Jersey pound is not the same currency as pound sterling. Jersey pound is not legal tender in the United Kingdom, but it has parity with the British pound as a purely economic matter. So Jersey takes...
Are you suggesting it's like the Irish punt until they adopted the euro?
My lady, yes. So there would be a defined relationship,
yes,
with the pound.
They weren't common currency, but they had parity.
Economic parity as a matter of exchange. And specifically, I'm submitting that it is not the same as a...
Complete parity, but it doesn't matter.
It's not the same as a Scottish pound note issued by the Royal Bank of Scotland in Edinburgh, which is part of sterling.
And is supposed to be accepted in England.
Not technically legal currency.
But one finds the further south one gets, the more difficult it becomes.
I'm not so sure.
But in your approach, that's essentially beside the point in any event. A critical issue is the applicability of a relevant provision of EU law.
Yes, yes, and it can't be said that currency is the only aspect which the free movement of capital law covers. The free movement of capital law is exceptionally wide, as we see in this case, because it's going to be argued this afternoon that it applies to gifts and bequests. My lady, unless there's anything further I can help you with, those are my submissions.
It appears not. Thank you very much, Mr. MacDonald. Mrs. Stifel.
My lady, my lords, view of the time I shall be short, particularly because Mr. MacDonald has covered, as I expected, virtually all the territory that I would have wanted to cover myself. So I will content myself with just dealing with 3 points, which were at the forefront of Miss Bacon's submissions. First of all, she emphasised the close association, as she puts it, between Jersey and the United Kingdom. Well, of course there is a close association. If there wasn't a close association, this question would not arise. The question arises because there is a close association which puts Jersey internationally in a somewhat unique position. That was something observed by this court in the Berkeley case. Jersey... And
well,
indeed,
that happened to be about Guernsey, not Jersey.
I should have said Channel Islands. The Channel Islands do have something of a unique relationship with the United Kingdom. As pointed out, by the Commission, they are regarded as independent of the United Kingdom. As Mr. MacDonald pointed out in his very first comment when he got to his feet, they do not belong to the United Kingdom and never have belonged to the United Kingdom. It was historical, if I can put it this way, accident that has resulted in this unique position, something that has been gone into by this court, and I won't go into it for present purposes because I take it that this court is well familiar with the accident of histories that resulted in the relationship between the Channel Islands and the United Kingdom.
Well, Lord Reid and I were both in,
Yes, in
Berkeley number 2, yes.
But it's not that close. For example, in relation to some of the matters that have been relied on, there is no monetary union between Jersey and the United Kingdom. The fact that they share the same currency, in the sense that the Jersey pound is kept at par with the English pound, is an occurrence that actually occurs in many places in the world. If I could just give, from my own experience, an example, which you may have had yourself, the Bahamas currency, the Bahamas dollar, is kept at par with the United States dollar. But there's no monetary union between the Bahamas and the United States. Ecuador has a currency which consists of the US dollar, doesn't have its own currency. But there is no monetary union between the United States and Ecuador. What one can see, though, and we see it actually in at least a couple of the documents which are in the bundles before this court, is that the United Kingdom does enter into agreements, treaties, with Jersey. There are two in this court, in the bundles in your court. The 1952 agreement for mutual assistance and the 2009 agreement. The first is in volume 1 at tab 7. If I can give you the electronic number is 408. And the later 2009 is at volume 4 at tab 50. So it begins at page 1596. I won't trouble you with reading them. It's just an illustration of the United Kingdom entering into an agreement with Jersey on the basis, which you can see from it, that they have equal bargaining rights, as it were. That this is an agreement between equals. So although the UK has responsibility for Jersey's external international relations, that does not in any way entail that that association is so close that for the purposes of EU law, it's to be regarded as a member state. Now, the high point of Miss Bacon's, the second point that was made, main point made by Miss Bacon, she says, you've got to look at it in context. Context is everything, she said. And she highlighted 3 different contexts in which the question could arise. But there is nothing in the EU jurisprudence to which you have been referred, and in which consistently it has been held that countries in a position such as Jersey are to be regarded, and indeed Jersey itself is to be regarded as a third country. There's nothing in the jurisprudence that suggests that it is because of the context. In each case, what the court is looking at, or the court has been looking at, is what provisions of the EU treaty have been made to apply to that country when, as it were, its host country joined the EU. Of course, UK has responsibility for international relations, therefore it has the ability to enter into treaties on behalf of the Channel Islands. It did so in 1972, it did so further when the Maastricht Treaty came in. And in each case, there's express provision in the protocol that the provisions of the treaty were not to apply, or only to apply, in regard to certain matters. Those matters did not include, as correctly observed by Lady Justice Arden in the Court of Appeal decision in this case, they did not apply to the free movement of capital. Incidentally, on that point, and I may have misheard, but I thought I heard Miss Bacon suggest that the Court of Appeal in this case had not decided this issue. It is true that in the light of the Court of Appeal's decision on the other, I've called EU matters, it may be that its decision on that point did not matter. But it did specifically determine this issue. And that's quite clear. I won't tarry, but the court, I'm sure, has looked at the judgment. That's quite clear from the judgment. Her Ladyship divided the issues. She made into a number of separate issues. The very first issue is Jersey to be regarded as a third country for the purposes of free movement of capital under Article 56. Now, the high point of Ms. Bacon's submissions appears to have been paragraph 45 of the Jersey Potatoes case. Just to remember, it's at page 1022, behind tab 24 in volume 2. Want to look at that. And it's a paragraph. It's appropriate, first of all, to recall that the court has previously stated that just as distinction between Channel Islands and other citizens, neither because of other aspects of status, can relations between the Channel Islands and the United Kingdom be regarded as similar between those two member states. In our submission, all that the court is doing there is prefacing the basis of which it then comes to the conclusion that for the purposes of the free movement of capital, for the purposes of free movement of goods, Jersey is to be regarded as a member state because, not because of the close relations referred to in 45, but because the relevant provisions of the treaty expressly applied to the Channel Islands. And that's the only reason why it reached the conclusion of paragraph 54. It didn't reach that conclusion in our submission. Yes, it recalls in paragraph 45 that there is a close relationship, no doubt to justify in some way that it isn't odd, therefore, that it should be regarded as a member state for these purposes. It has, after all, a close relationship. That's all in our submission that the Court of Justice is saying in that paragraph. It's not giving it as a separate reason, but as a background to its conclusion, which is based simply on a reading of the treaty. That, of course, was a view that Lady Justice Arden took in this case, and we respectfully submit that that was a correct view. The other was the XBV case, which I won't take you to, but in the XBV case, the Advocate General expressed the view that the Netherlands Antilles was to be regarded as a third country for the purposes of applying the relevant provisions. It's true that the court itself, they came to the view that, in fact, the Netherlands Antilles was to be regarded as an OCT, and there was a separate directive that dealt with OCT, so they came to the same conclusion, but by reason of that directive. There is no suggestion in the Court of Appeals, in the court's judgment in that case, that they were disagreeing with the basis of the Advocate General's view in relation to a third country being capable of being, OCT being capable of being a third country for the purposes of its own, as well, host state, which is the way, state to which it's associated. So, my Lord, my Lady, for all those reasons, we would respectfully submit that the Court of Appeal in this case was correct in concluding, per the judgment of Lady Justice Arden, that it is clear that for the purposes of the application of Article 56, Jersey is to be regarded as a third country. It would lead actually to an odd conclusion in this case, Jersey being regarded as a third country effectively for the purposes of the application of the very statutory provision that this court is being asked by this appeal to look at, section 20, the meaning of charity for income tax purposes and then for the purposes of inheritance tax. The decision in Dreyfus that those words only apply to charities established in the United Kingdom, but Jersey isn't part of the United Kingdom for that purpose, something we accept, but for another purpose which actually preserves freedom of capital between the two, Jersey is to be regarded as part of the United Kingdom. I don't say it's an impossibility, but it's an oddity, which is something that perhaps throws further light on the question that this court has to consider. We respectfully submit that it is clear, or if I can use the continental expression, act clear, that Jersey is to be regarded for these purposes as a third country. Unless I can assist you further, those are my submissions.
No, thank you, Mr. Steinfeld. Ms. Bacon, you better have a right of reply on this point. Can you make it?
I hope so. I've got a handful of preliminary points and then a short...
Mr. MacDonald wanted to say something, and so...
I do apologise. I made one slight error in what I said about Jersey's status under international agreements. The position is accurately set out in Berkeley at paragraph 11, that Jersey's consent is sought and by convention now required.
Yes, that's
I do apologise for writing.
Am I right in taking it that no one is taking issue with the constitutional position of Jersey as set out in Berkeley? Yeah, that's fine.
On that, yes, on that topic. Yes. I don't think the bailiff of Jersey was completely happy with every aspect of the Berkeley decision.
But for the purposes of this hearing.
Yes. Right, Ms. Bacon.
My lady, my lords, a few preliminary points, and I will respond to some of the submissions on the cases. I hope you will take it as read that I won't respond to everything if I've already dealt with it sufficiently in my opening submission, so I hope not to repeat myself. My first point was exactly the point just made, that it is common ground that the position of Jersey under domestic law is, well, as set out in our written case and also as set out in the intervener's written case and in the Berkeley judgment, and we're not demurring from that. And I hope that my submissions this morning were not to be taken in any way as trying to retract or elaborate on what we'd said in our written case regarding the constitutional status of Jersey under domestic law. I'm not suggesting that the UK owns Jersey. What I'm saying is that Jersey is associated with the UK in the sense that for the purposes of EU law, it is a territory, it is a European territory for whose international relations the UK is responsible. And so by referring to association, or in some colloquial senses, our territory, that is simply a shorthand for that rather longer description. But there is, as I understand it, no difference between us as to the domestic constitutional position. Nor was I suggesting that the Court of Appeal hadn't decided this point. If it hadn't decided it at all, then there wouldn't be an appeal before you. My point was that the Court of Appeal, by the structure of its analysis, didn't need to decide this point, and that was essentially the position taken by the court in Prunus. The third preliminary point is that we are not, of course, saying that the fact that the UK is responsible for Jersey's international relations makes Jersey part of the UK for all purposes. We are saying exactly the opposite, that the position is more nuanced and is context specific. And there are purposes for which, in the context of, for example, data protection or financial services regulation, where there's no question, and we do not dispute that Jersey is referred to alongside other territories as being a third country. But my submission was that it does not inexorably follow from that that in the quite different context of a free movement of capital between the UK and Jersey, Jersey should also be regarded as a third country. So we are not saying part of the UK for all purposes. We are saying in this particular context, the correct analysis is that there is an internal situation. The last of the preliminary points can be summarised by an economic maxim, which is that correlation does not imply causation. Mr. McDonnell tries to set out a framework for the analysis of these cases into which he says the existing cases can be fitted. And we don't dispute that one could fit the outcomes in those cases into his framework. But of course, it is not just the outcomes that are important. What is important is the process of reasoning to get to those outcomes. And on that, none of the cases before you, save for the XBV case, even ask the specific question that is raised by the third country issue in those cases, let alone do they decide it. None of those cases, then unsurprisingly, articulates the distinction drawn by the intervener. And in fact, the distinction drawn by the intervener, turning decisively on whether Jersey or whether the associated territory is subject to the relevant European law, that distinction would be inconsistent with the reasoning in Gibraltar for the reasons that I've shown you. If that was the decisive and the sole criterion, several paragraphs of Gibraltar, the judgment, wouldn't have been there, wouldn't have needed to be there, nor would paragraph 45 of Jersey Potatoes have needed to be inserted. And also, if there was an inexorable logic and a clean framework as set out by the intervener, that would also have provided a complete answer in the XBV case. And there is no reason why the court had to avoid answering the question. It could easily have decided it if the position was so clear as set out by the intervener. So those were my preliminary comments. Now, just to pick up on some of the comments made on the case law, starting with the Jersey Potatoes and the Gibraltar cases that both Mr. McDonnell and Mr. Steinfeld said could be understood as referring to the point about the relationship between the UK and the relevant territories as being a preamble point or a discursive point. And the discussion of the Gibraltar case in my opening submissions shows you why that is not the case. Gibraltar made quite clear that paragraph 45 of Jersey Potatoes was not a preamble, but was one of the two key limbs for the decision in that case, as it was also one of the two key limbs in the decision of in the Gibraltar case itself. So that answers the point regarding Jersey Potatoes and Gibraltar. The third country point, or the internal situation point, was not simply a passing comment, but was an important and key part of the court's reasoning in those cases. Then turning to Van der Kooi. And Van der Kooi was, as I said in opening, a quite different case. It's been painted as being a case about free movement. But if one looks at the judgment, you can see that the question asked was about the territorial scope of the Sixth VAT Directive. It did not concern capital movements. The question before this court was not asked there, nor was any remotely similar question asked in that case. And I come back to the point that if that judgment provided a clear answer on the relationship between the Netherlands and the Netherlands Antilles for all circumstances, then that would have been the answer that the court could have given in XBV, but it didn't. Commission in UK, the same point applies. This was not a judgment about free movement. Free movement between the UK and Gibraltar was not the issue there. The Commission in UK case was a case in which the sole issue was whether for all purposes certain provisions of EU law applied in Gibraltar. Again, it was about the territorial scope of EU law. It was about whether the UK had failed in its obligations under the EU treaties by failing to implement certain directives in Gibraltar. So the question here again was not remotely relevant to that case. Prunus was the next case referred to by my learned friend Mr. MacDonald. And again, if that had provided the answer, then one would have expected the court to have given that clear answer in XBV, but it didn't. And there's another point on Prunus which I should make, which is that there is, with respect, some doubt as to whether Prunus even remains good law in the light of the XBV case. Because, of course, in XBV, the court did have before it a decision on very, very similar issues to those in Prunus. And rather than deciding the question on the basis of Article 56 or 63, there's a free movement of capital rules in the treaty. The court in XBV said, effectively, that the OCT decision displaced the treaty rules on the free movement of capital. And given the terms of the XBV judgment, there must be some doubt about relying on Prunus for any proposition concerning the application of Article 56. Essentially, the court was invited, in fact, the Advocate General in XBV invited the court to determine the case on a very similar basis to the basis set out in Prunus. The Advocate General in XBV repeatedly referred to the Prunus decision in his opinion. He also referred to Van der Kooi, and he was essentially inviting the court to decide the case on the same basis as it had done in Prunus, and the court decisively rejected that analysis. And it's not a case that one can say the court must be taken, or could be taken even implicitly, to have endorsed what the Advocate General said. It didn't endorse it at all. It profoundly disagreed with the Advocate General's analysis and reached its own conclusion, and one in which the question on which the Advocate General had devoted so much of his time and energy regarding the internal situation was simply left open. It wasn't that one can read into that it didn't agree, that the court might have agreed with the Advocate General. The court explicitly left open the question. And as I've said, if the previous cases had provided the clear pathway through that is depicted by my learned friends, then there is no reason why the court couldn't have adopted that pathway, but it chose not to. As a final point, regarding currency union, stroke monetary union, the position, as far as we are aware, is correctly set out in paragraph 32 of our written case, which is that although there is not a formal currency union with the UK, there is de facto monetary union, that there is a currency board arrangement with sterling. Bank of England banknotes are accepted as legal tender, but Jersey also issues the Jersey pound, which is kept at parity with sterling. And the remainder of paragraph 32 is there. I don't need to read it out, but that has been checked by those behind me, and I believe within other departments as well. We believe that that correctly sets out the position on currency union. But of course, as I explained in opening, we are not saying that this is decisive. It is purely a further contextual factor in a case where, as we submit, the context is very important. My lady and my lords, those are our submissions in reply. And I apologise for being 5 minutes over.
I'm not sure that you should apologise. We set you a task, and you have managed to complete it within a reasonable time. We will certainly hope to return at 2:05, but we won't necessarily guarantee that we'll do that. We'll now adjourn.